I think we can chalk another win up to the People's Convoy. Hello and welcome to Sweet Home California. My name is Jennifer, and the People's Convoy left from D.C. I think it was March 30th, 31st, and they went cross country all the way back to California, where they started from, because of a slate of 10 bills that they thought were so egregious that it demanded attention, because unfortunately what starts off in California often spreads like a cancer throughout the rest of the United States. And so these 10 particular bills that were all pandemic era related needed to be addressed and needed to have the light of day shown upon them, so that hopefully people would rise up and contact their legislators and let them know that these needed to be tabled. They needed to be taken out of consideration. Well, I'm going to report today on SB Bill 920, which is now the third of the 10 that has been tabled. And so I'm really excited about that. And you can let me know in the comments below your thoughts, whether you think the People's Convoy had anything to do with this, or if the legislators just came to their senses all on their own. I'll let you let me you tell me that, what you think. Okay, hold on just a moment. Let me get this set up, and I will bring you over to my other screen here. Okay, I will have a link in the description to how you can keep track of these laws under consideration in the state of California. So anything that's proposed by the Senate or the Assembly House, you can look for in here. So any bill that starts with AB or SB, you'll be able to find by just clicking on the link to search for the bill, and I'll have the link down below to this particular bill. So this was introduced by Senator Hurtado on February 3rd, 2022. And you ask, all right, well, why are you even spending time going over this when the bill has been tabled? Well, just because it's tabled right now doesn't mean it can't be brought up again later. And the fact that they already have a bill in place, the process for getting it started back up again, my understanding is that it can go a lot faster, so long as they think that they have the support for it. So we need to continue to put pressure on them to make sure that this stays tabled. So I just want to give you a quick rundown on this as to what it was about. Okay, so basically it's about a records request. So it was seeking to amend section 2220.8 to the Business and Professions Code relating to the healing arts. The Legislative Council Digest it says that the existing law, the Medical Practice Act, provides for the licensure and regulation of physicians and surgeons by the Medical Board of California. Existing law provides that the board is the only licensing board authorized to investigate or commence disciplinary actions relating to physicians and surgeons as specified. This bill would authorize a board investigator and medical consultant at the discretion of the board to inspect the business location and records of a physician or surgeon, including patient and client records. The bill would provide that in the case where consent of a patient to inspect patient records is not present, the board investigator and medical consultant may inspect records in the office for the licensee for the limited purpose of determining whether good cause exists to seek a subpoena for those records. That's where we were upset. That's where we thought that this was unconstitutional, because even if the patient said no, and they don't have necessarily cause to look at those particular records, they want to look at those records so then they can establish cause. That's totally against the Fourth Amendment, where you're supposed to have good cause before you start investigating. Additionally, existing pharmacy law provides for the licensure and regulation of the practice of the pharmacy by a 13-member California State Board of Pharmacy, which is in the Department of Consumer Affairs. So this bill would authorize the Medical Board of California to request records and other information from a pharmacist in conducting an investigation of a pharmacist licensee. And the bill would do the same thing. It would require the pharmacist receiving that request to respond in the same manner and time frame as if the request came from the California Board of Pharmacy. So now the pharmacist has to answer to two different state regulatory boards. And the same thing, all of their pharmacy patients, whether or not they had allowed for the state to look at it, if the state feels they need to, they will, just so they can build a case, even though they may not have a case ahead of time. All right, this bill would, but the part that could have been good is this. So this is the only good part of this bill, and this is what the LA Times, when they were talking about SB 920, this is the only thing the LA Times talked about. And I'll put a link to their article down below if I can find it, if they haven't taken it down, because it was, very misleading, their article. Imagine that. And that is this. The Medical Practice Act also establishes the procedures for formal disciplinary proceedings and requires that complainants against licensees who are subject to disciplinary proceedings be notified of the actions proposed to be taken against the licensee as provided. So this is talking about medical malpractice. If you put a complaint against a doctor, it gets investigated. And the medical board is required to inform the person who put in the complaint. However, this would provide for some more transparency and allow input from the person who had complained against that particular doctor. So now this act would have allowed complainants the opportunity to provide a statement to the Deputy Attorney General from the Health Quality Enforcement Section who is assigned to the case. Under the act, these statements are not considered for purposes of adjudication, but may be considered after final adjudication for purposes of setting generally applicable policies and standards. This bill would also allow these statements to be considered for purposes of adjudication and would require these statements to be made under penalty of perjury. By expanding the crime of perjury, this bill would impose a state-mandated local program. And saying that the California Constitution requires the state to reimburse local agencies and school districts for certain costs mandated by the state. Statutory provisions established procedures for making that reimbursement. So continuing on, so that might have been a good thing, if they had just stuck to, we want to hear from people who have been harmed by a physician or a pharmacist under malpractice. That I definitely could have gotten behind that. It's the other part, the first two parts that I talked about, where if a patient didn't give permission for the state to look at their records, that the state is just going to go ahead and do it anyway. I don't understand why bills can't just be narrowly tailored to what is the problem at hand. They always want to have the poison pill in there. So continuing on, how the law would have actually read, so what I just read before was like a legislative digest. So it would have said that Section 2220.5 of the Business and Professions Code is amended to read that the Medical Board of California, again, is the only licensing board that is authorized to investigate and conduct disciplinary actions relating to physicians and surgeons that have been issued pursuant to Section 2050. At the discretion of the board, part of the investigation, let me see if there's anything new. The way that they write these bills, I'm finding that they just do a lot of repeating of stuff. Yada, 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 yada. Yeah, so there's nothing new in here. It's all, except for that it says that a violation of the section is not a misdemeanor. So I don't know exactly what that means. Does that mean it's a felony? Is it less than a misdemeanor? For a bunch of lawyers writing bills, they certainly do come up with some things that are very open to interpretation. Yeah, so the good part of it would have been about the complainants, that they should be given the opportunity to provide a statement. But here's something interesting. So it says that no reimbursement would have been required by this act, by the Constitution, because California has a law that if they impose something on a local county or local city that's going to cost them money, then the state of California is supposed to reimburse them for those costs. And under this bill, it would have required, I guess, more investigatory things going on. But they decided that no, that we weren't going to have to reimburse them, because if California comes up with a new crime or infraction, then they don't have to reimburse the local counties and towns for the increased cost. So I don't know exactly how that works, because of course everything that the state does can impose it as a new crime or penalty or whatever. And so they can kind of get out of the fact that they were supposed to reimburse these local municipalities and everything. Well, anyhow, I'm not going to spend any more time on that, because the good news is, as of right now, it's been tabled. So let's keep it tabled. If they want to bring back just that limited section where a person who's been harmed by a doctor can provide a statement, that I agree with. But as for the rest of it, it needs to stay where it is, and that's on the table and not taken up. So anyhow, God bless. Let me know your thoughts in the comments below, and like, share, and subscribe, and I will talk to you next time.